mechanism to safeguard the backward classes and scheduled castes. As such, provision for reservation was adopted in the Constitution. Reservation to the socially and economically deprived people as such is not a new concept enshrined in the Indian Constitution, but has been in existence in the pre-constitutional era as well. It is important to mention here the reservation granted by the former princely state of Mysore on the recommendations of the committee set up in the year 1918. The demand for some kind of affirmative action had also been taken up before by people like Jyotiba Phule and others, and the British did give reservation to some of these classes, but their motives were always suspect. Over the years, reservation has become more of a political tool than an earnest attempt to establish an egalitarian society. A landmark in the issue of reservation was the judgment pronounced in Indra Sawhney v. Union of India Ors by the Supreme Court. What follows is an attempt to summarize this important judgment. In the year 1979, the then Prime Minister Shri Morarji Desai appointed the Second Backward Classes Commission under Article 340 of the Constitution. The commission was headed by B.P. Mandal, and its mandate was to investigate the status of socially and educationally backward classes in India. When the commission finally submitted its report in 1980, it recommended a reservation of 27% in government jobs for these castes. The collapse of the Janata Party government complicated matters, and the recommendations of the report could not be implemented. There wasn't much progress in this respect for several years until Janata Dal regained power in 1989 and decided to implement the recommendations of the report and reserved 27% of the seats for socially backward classes. This was followed by reservation and anti-reservation protests in large parts of the country, some of which led to riots. When the government action was challenged before the Supreme Court by way of a writ petition, the then Prime Minister P.V. Narasimha Rao brought in another order which increased the reservation limit to 37% while including economically, socially, and educationally backward classes as well. The 5-judge bench referred the matter to a 9-judge bench. Issues before the court. The court further framed issues, the adjudication of which was essential to deal with the situation at hand. Some of these issues were whether caste on its own constitutes a different class, and whether economic criteria could by itself be the determinant of a class, whether Article 16.4 was an exception to Article 16.1, and is exhaustive in itself of the rights of reservation. Does Article 16.4 allow classification of backward classes into backward classes and most backward classes, or permit classification among them based on economic or other considerations? Contentions of the petitioners. The advocates for the petitioners, led by Nani Palkiwala, argued that reservation further provoked the evil of the caste system, and this evil will hamper India's march towards being a welfare state. They further argued that if the reservation was continued, it will replace standard with substandard and meritocracy with mediocrity. Petitioners also alleged that the Mandal report was in essence trying to rewrite the Constitution. Contentions of the respondents. The respondent state said that the report merely gives the backward classes a means to fulfill their just claims. They argued that the report was a continuation of the First Minorities Commission, which also recommended affirmative action to right the wrongs that backward classes have faced for centuries together. The court in its judgment laid down the following rules. Backward classes under Article 16.4 cannot be identified on the basis of economic criteria, but the caste system also needs to be considered. Article 16.4 is not an exception to Clause 1 but an instance of classification as envisaged by Clause 1. Backward classes in Article 16.4 were different from the socially and educationally backward classes mentioned in Article 15.4. The concept of a creamy layer was laid down, and it was directed that such a creamy layer be excluded while identifying backward classes. Article 16.4 does allow the classification of backward classes into backward and more backward. Reservation shall not exceed 50%. Moreover, reservation in promotions shall not be allowed. Any new disputes regarding criteria were to be raised in the Supreme Court only. After Indra Sawhney case, a number of developments in the reservation have taken place after the Indra Sawhney case. The Parliament responded by enacting the 77th Amendment to the Constitution by adding Clause 4A to Article 16 in 1995, by virtue of which powers are conferred to the state to reserve seats in favor of SC/ST in promotions in public services if communities are not adequately represented in public.